Thank you. I'm pleased to introduce tonight's speaker, the Honorable Jed Rakoff, Judge of the United States District Court in the Southern District of New York. Judge Rakoff was appointed to the bench by President Clinton after many years as a distinguished practicing lawyer and public servant. Among other things, he served for many years as an assistant U.S. attorney in the Southern District. Judge Rakoff has a full calendar of cases, but has found time to write and speak extensively on a number of important issues dealing with our legal system and the judiciary. He is a regular contributor to the New York Review of Books, and one of his most recent articles, entitled "Why You Won't Get Your Day in Court," discusses the economic and other aspects that limit the accessibility of our courts to most of the American people. He has also written on why people plead guilty, why innocent people plead guilty, and he is known to be a fierce and outspoken advocate for justice and common sense in the courtroom. His opinions have addressed a wide range of issues, including freedom of the press, Wall Street greed and irresponsibility, and the death penalty. Not that I want to connect the last judges. Judge Rakoff was reared in Philadelphia, earned degrees at Swarthmore, Oxford, and Harvard Law School, but more importantly, as I've learned since I've lived in Philadelphia, he's a graduate of Central High School. That is the gold standard of Philadelphia's education system, I understand. Tonight, Judge Rakoff is the first in the series Rosenbach dealing with the Federalist Papers. He will speak on Federalist number 78, which is addressed to the people of New York by Alexander Hamilton, and deals with the role of the judiciary under our Constitution. I note that Hamilton wrote that the judiciary is beyond comparison the weakest of the three departments of government. When he wrote that, he probably did not contemplate the power of our speaker tonight. Judge Rakoff.
Well, thank you so much for that very kind introduction. I always feel very grateful, though, that my wife is not here because she would demand rebuttal time. I did grow up at 2028 Locust, and I remember my mother saying that the really chic people lived on Delancey Street. So, but it's delightful to be here. But before I say anything further, I need to tell you that under federal law, I am precluded from commenting on any pending case, not just before me, but before any judge. And I am precluded from commenting on any issue that is likely to come before me for decision in the immediate future. So that concludes my talk. Thank you so much. Fortunately, the Federalist number 78 is not too likely to come before me. But when I was in school at Central, and I'm sure the same was true wherever you went to high school, and you learn as maybe part of your history class, the basic, what used to be called civics. And what you all learned was that we had a government of three branches, and they were designed so cleverly by the founding fathers to be checks and balances on each other. Well, I want to suggest to you that the judiciary has served as a reasonably good check on the legislature, but not on the executive. And that may be of concern in times when there is allegations of excess by the executive. If you go back to the Constitution, on its face, it doesn't really specify how the courts will exercise their power of checking either the executive or the legislature. So the natural thing to do is look at the Federalist Papers. And the leading author of the Federalist Papers on this issue is Hamilton. And Hamilton, perhaps because he favored such a strong executive, was much more honed in on the role of courts vis-a-vis the legislature and not vis-a-vis the executive. He wrote 6 Federalist papers regarding the role of the judiciary. They were all designed, picking up on the point that was just made, to satisfy people who were uncertain of whether they would vote for the Constitution, that you might have to worry about the legislative branch, you might have to worry about the executive branch, but you certainly wouldn't have to worry about the judicial branch. As he says in Federalist number 78, the judicial branch may be said to have neither force nor will, but merely judgment. Well, what good is that? And he famously described the courts as the least dangerous branch because specifically they didn't have power over the purse and they didn't have power over the sword. But when he did hone in on judicial review, which he made clear was a role he expected the courts to play, it was all in terms of the legislative branch. So in Federalist 78, and you can go out there, and if your eyes are better than 20/20, you can even read it because it's sitting right there in the table. But anyway, he said, the courts were designed to take an intermediate role between the people and the legislature in order, among other things, to keep the latter within the within the limits assigned to their authority. So for him, the role of the courts was mostly to serve as a check on the legislature. And this came to a head fairly quickly in the very famous 1803 case of Marbury versus Madison. I know I'm surrounded mostly by lawyers, and I'm duly intimidated. But just to remind you of what you probably mostly know about that sort of strange case. So after Thomas Jefferson was elected president, and the Federalists were worried that he would do away with all that they had tried to accomplish in the presidency of John Adams, they appointed a bunch of last-minute judges, 23 judges who were appointed after, nominated and confirmed by the outgoing Senate after Jefferson had been elected. And they were known as the midnight judges because their commissions didn't get ready to be signed until the night that the presidency of John Adams ended. John Adams' Secretary of State, who was the person who was supposed to sign these commissions, was some guy named John Marshall, who didn't disqualify himself later from hearing the case. Things were a little looser then. So Marshall did get around to signing a whole bunch of these, but he missed a few. And one of the few that he didn't get around to signing was a Justice of the Peace of Washington, D.C., William Marbury. Now, that was, as today, not the most powerful position one could have, but still, Marbury wanted his position. The new Secretary of State, James Madison, who, by the way, was a distant cousin of John Marshall, who was also related to Thomas Jefferson, is very, it's like a Philadelphia Jewish family. So anyway, Marbury sues, and Madison, the new Secretary of State, refuses to sign the commission. So Marbury brings an action, and it was brought as an original trial in the Supreme Court. Wouldn't be possible today except in very unusual circumstances, but it was then. So this was not an appellate decision. This was a trial decision. But the whole 6-member Supreme Court sat as the trial, and it wasn't a trial by jury because the remedy he was asking for was an equitable remedy, Mandamus. In the opinion, authored by Chief Justice Marshall, Marshall first makes a point about, there's no question that what Madison did was wrong. He definitely should have signed this. By the way, Jefferson had already let word leak out that he would not enforce the decision if Marshall did in fact force or issue an order, issue an opinion directing that Madison be forced to sign. So anyway, but says Marshall, the Supreme Court lacks the power to issue mandamus at the trial level. This, you'd have to know more about English common law than I think you and I would want to know why there's a distinction there between the mandamus at the trial level and mandamus at the appellate level. But the Judicial Act of 1782, which was the relevant statute, had given the mandamus power to the Supreme Court across the board. And so what Marshall says is that was an unconstitutional law. We have the power to decide what the law is. Very strong language throughout that part of the opinion about the role of the court as being the final arbiter of what the law is. And we interpret this law to be unconstitutional, and therefore it's void. And since, therefore, we don't have the mandamus power, we can't force the executive, Mr. Madison, to sign the commission for Mr. Marbury. So most people focus on the fact that this was a great opinion asserting judicial power over the legislative branch, over Congress and over its legislation, and it was. But it should not be forgotten that it was in many ways, a weak decision when it came to the executive. He really backed down in the face of Jefferson's threat not to enforce the decision. So even though he has lots of language in there about how Madison is really wrong, nothing issues that forces Madison to comply. And in fact, Mr. Marbury never did become a justice of the peace. Now, why do I mention that? I think that and also the language of Hamilton in the Federalist Papers were a portent of what was to come. And I think if you look at the last 200 years of judicial history in the United States, and particularly Supreme Court history, you find the courts carving out one judicial doctrine after another, judge-made doctrines that can be found nowhere in the Constitution, but that greatly limit the power of the courts to take action in the case of executive excess. So let me give just 9 examples, and I could give you 100. The one is which might seem like the most obvious, the war powers exception. You know, the Supreme Court early on said, we're not going to interfere with the conduct of war by the president. Well, you can sort of understand that if you're talking about like battlefield decisions and things like that. But what was the famous case in this area? It was the terrible, awful case of Korematsu in 1944. So a mid-level general at the Pentagon had decided shortly after Pearl Harbor that we had to round up all Japanese Americans, about 100,000, mostly in California, 60,000 of whom were citizens, American citizens, some of whom had been there for several generations, because they were a security threat. And that they would be placed in what were called internment camps. We couldn't call them concentration camps because Hitler had already taken that one. Mr. Korematsu sued. He gets up to the Supreme Court, and by 6-3, an opinion written to his shame by Hugo Black, one of the great libertarian judges of all time, the Supreme Court says, we have to defer to the executive. They know what's right to win this war, and this was just an exercise of their war powers. Terrible decision. Closely allied to that is the doctrine that the courts will not interfere with the exercise of the executive's powers when national security is involved. So After Guantanamo, at first there was torture there. That was overturned not by the courts, but by Congress, to their great credit. But then the CIA began sending some people who they really wanted to find out what they knew to countries that would torture them. This was called rendition. And it occurred no more than 10, 15 years ago. And the people who were being sent to countries where they were in fact tortured then brought suit, and the Supreme Court said, we're not going to get into the merits because it would involve us interfering with states or revealing state secrets, and that would compromise national security. So we're not going to touch that either. And then on a much broader but often more mundane level, there is the so-called foreign affairs exception. So I had a case in my court a few years ago where there are a whole bunch of countries who have foreign missions to the UN who own entire buildings. And for example, India owns a 26-story building, of which only 6 floors are actually used for anything remotely related to their UN activities, and they rent out the rest, some for commercial purposes, some for other purposes, and they make money. And so the city of New York brought an action to collect real estate and other taxes on those 20 floors. I held in favor of the city, and it went up to the Second Circuit. And after oral argument, when it looked like the court, at least from many observers, was going to affirm my decision, the State Department issued a notice in which it said, we have determined that it would be contrary to the foreign national interests of the United States, the interests of the United States in the proper conduct of foreign affairs, to tax any part of these buildings, not just of India, but anyone, any foreign country. And the Second Circuit then wheeled around and issued an opinion and said, well, we don't reach the merits because we defer to the determination of the State Department that this would interfere with foreign affairs. Another doctrine that is very difficult to define but very often invoked is the so-called political question doctrine. For many years, although this may be possibly changing, we'll see. For many years, gerrymandering was considered a political question and not to be interfered with by the courts unless there was racial bias. So the notion was the Constitution leaves it to the states to determine federal districts, and even though they're federal districts, this is something that is really of its nature inherently political. The court did intervene, of course, famously in Bigger v. Carr, one man, one vote. That had a big impact. But other than that, they've only intervened when it's been invidiously racial. Now, a 3-judge court just determined in North Carolina that it was politically invidious. And they did take jurisdiction, and that's going up to the Supreme Court. I'm barred from expressing any opinion on that. But my point is this, at least up till now, the courts have said, if the nature of the question is political in its essence, we won't touch it. And that encompasses a very wide swath of cases. Another such doctrine that I think will be familiar to all the lawyers here is the doctrine of standing. So there's nothing in the Constitution that says you have to have certain requirements to bring a case, but Article 3 and the separation of powers clauses have been interpreted that number one, you have to have a personal injury. Okay, that makes a certain sense, although it means that all the public interest groups have great difficulty bringing any action. But in a case that came down in 1975 called Worth v. Selden, the court determined that your injury, even if you have a personal injury, has to be unique to you. It can't be something that is general. And here are the facts of that case. There's a suburb of Rochester, New York called Piedmont, and it's a very nice community, very upscale. The zoning board of Piedmont was interpreting its zoning laws in such a way to keep out anyone who was poor or middle class. They wanted exclusively a rich community. And they found often inconsistent ways to interpret their zoning in order to achieve that. So no relief was found in the state courts, so an action was brought in the federal courts, went up to the Supreme Court, and the Supreme Court held no standing because even though every member of this class had an injury, namely they all wanted to live in Piedmont, there was no special injury. It was a across-the-board injury, and that said, the Supreme Court is sort of like a political question. And so they were denied standing. The big proponent of that very narrow view of standing was the late Justice Scalia, who is, in my view, the best writer on the Supreme Court in the last 20 years or so. And he had an opinion that was full of good, sort of quips. And he said, it's important under the separation of powers that the court mind its own business. But I would suggest to you that what is the business of the courts is the question. And so this was sort of a circular remark, clever though it might have been. Another limitation is, of course, sovereign immunity. You can't sue the government, state or federal, unless it gives you permission to do so, which they do sometimes, but not always. You can't sue a prosecutor who has absolute immunity. You can't sue a judge. Okay, so there are some good things here, but you can sue a policeman, but he has so-called qualified immunity. So what he has to have done is something really bad before he can be sued. Now, where do they get all this? They get this not from the Constitution. They get this from the common law notion that the king can do no wrong. Now, I had a memory, I'm sure you'll correct me, that we fought a revolution because we didn't agree with that. But there it is, and in full force today. Sometimes the limitations are imposed by Congress, but the courts embrace them. There's a terrible law called AEDPA. It stands for Anti-Terrorism and Effective Death Penalty Act. Touched a lot of bases there. A Clinton proposal came out of the Clinton administration, supported by both sides. And what it does is tremendously reduce the ability of a federal court to take a case from the states under habeas corpus. Now, habeas corpus, which is right there in the Constitution, is, of course, a writ that says if you're being held by the executive, in this case usually the state executive, and you feel it's contrary to federal law, you can apply for a writ of habeas corpus, and the federal courts will then review what's going on. A great many of the greatest decisions of the Warren Court, the court that made me so proud to be a lawyer, were habeas cases. But after Congress passed AEDPA, the law now is that you do not have standing to bring a habeas action or get habeas relief unless the state court's decision was contrary to, quote, clearly established federal law. Well, of course, all the great cases, as the Warren Court demonstrates, were cases where it wasn't certain. There was no constitutional clear right to a lawyer if you couldn't afford one in a criminal case until Gideon, and that was a habeas case. So the result of all this is there have been very few meaningful decisions in habeas jurisprudence since this law was passed in 1996. There's some other limitations. Citizenship is sometimes, though not always, invoked as a requirement for standing, which of course has relevance to some of what's going on currently. And there's a doctrine that, I'm a good God-fearing liberal. Well, I don't know if liberals are God-fearing, but anyway, there's a law that many liberals support, which I think is also illustrative of this mistaken view of very narrowed judicial authority, which is Chevron, which is a case that came down about 20 years ago and deals with the decisions of administrative agencies, and in particular, their interpretation of federal law. So Congress passes a law saying, dealing with securities. Before Chevron, the courts would determine what that law means. After Chevron, the SEC determines what that law means, and unless the decision of the administrative agency is an impossible decision, not one that's a reasonable alternative, it must be given deference by the courts. All of these are doctrines that were made by judges, mostly Supreme Court judges. None of them, in my view, are remotely in the Constitution. There's a little hint of it in Federalist 78. There's a little hint of it in Marbury versus Madison. And so why are the judges doing this? It seems a little unnatural to be so constrained. Well, the usual reason that's given is that judges are supposed to be above the fray. We're not involved in the day-to-day hustle and bustle of the political controversies. We are one step removed. There's something to that. I think every judge within maybe a year or two of taking office decides a case differently from how he would have decided it if he were writing the law, but he knows he's bound by law that goes the other way. Nevertheless, the notion that judges are not part of the controversy of controversial issues is, in my view, unsupportable. If Roe v. Wade had gone the other way, would it be any less controversial? If Brown v. Board of Education had gone the other way, would it have been any less controversial? These are major issues, and the court gets to them, and often through these doctrines, it ducks them, but ducking them is itself a political act in many, many cases. So I don't think that's the real heart of what's going on. I think part of what's going on is what bothered John Marshall way back when, a fear that the executive will not enforce the laws and the rulings of the federal judges. Unless you think this is something that only could have happened way back then, and it did happen not only in Marbury versus Madison. There's a famous opinion by, a famous statement by Andrew Jackson when the Supreme Court came down with one of its very, very few pro-American Indian opinions written by John Marshall. And Jackson allegedly said, John Marshall has made his decision, now let him enforce it. And in fact, it never was enforced, and the result was the Cherokee Indians had to do a 120-mile forced march to a new territory where they put on a new reservation, giving up everything they had created for the last many decades before. But consider Brown v. Board of Education. When that decision came down, many of you may remember, I'm old enough to remember, most Southern governors said, we're not going to enforce it. Perhaps the most extreme was Governor Faubus in Arkansas, and he actually called out his own police and other and National Guard to prevent these young black children from entering the schools of Little Rock. So it was up to Eisenhower what to do. A number of historians have said that Eisenhower at first was not going to do anything. Not because he was sympathetic to Faubus, but because he feared the tensions that would arise, as unquestionably they did, in enforcing that very important decision. He was finally persuaded by a guy who people have forgotten about, but was really a terrific Attorney General named Herbert Brownell, who was his first Attorney General, who also was the person who got him to select Earl Warren to be on the Supreme Court. And Brownell basically said, it's the law of the land, you must enforce it. And Eisenhower did, and the rest is history, as they say. But I think it's that fear that important decisions may not be enforced that is way in the back of the minds of many judges. It has been for decades, and prevents them from reaching issues that they should reach. There's one other factor, and this I'm less sure about. Maybe in the question and answer period, other lawyers may want to comment on it. I think the Anglo-American legal system, wonderful though it is inherently a conservative system. And that's because it is so much dependent on stare decisis. If you go to a civil law country like France, the judges try to decide a case. They have a code. Oh, is this covered by item X or item Y in the code? And that's true throughout most of the world. But in countries that have the Anglo-American approach, the question is, what's the closest precedent? And I think that while that sounds neutral, its effect is really a conservatizing force, including in these areas of keeping somewhat narrow the scope of judicial review of the executive. Now, I don't want to leave you totally with this negative picture, although it is 90% of what I'm saying. There have been occasional exceptions. There are 3 in the last several decades. One was Truman's seizure of the steel mills during a strike early in his presidency. And he said, this was 1950, he said, I have to take over the steel mills and prevent this strike because we're fighting a war in Korea and we're going to need steel to support our troops. All the evidence, internal evidence, shows that was not his real motivation. That's what he was using as a crutch, but it was a decision really reached on other grounds. Truman, who I greatly admire in many, many ways, was a very strong-willed president, and he felt this strike was being harmful to the economy of the country. That was his real reason. Supreme Court pierced through that and said that's his real reason, and that's not, he doesn't have a constitutional right to seize the steel mills. So that was one decision. Another decision was the Watergate tapes. So when everyone found out during the Watergate hearings that Nixon had been taping everyone in his office, which, by the way, Kennedy and Johnson were also doing. In fact, I invite you to go down to Austin, Texas, and listen to the Johnson tapes, because you'll never hear such salty language in your life. But in any event, in Nixon's case, of course, the tape showed he was a crook. They were subpoenaed, and he could have first destroyed them. A very great lawyer named Leonard Garment convinced him not to destroy them. But instead, they invoked executive privilege. And this would have been an easy one for the Supreme Court to duck, executive privilege. This interferes with the workings of the executive. That, how are they going to operate in a meaningful way if everything they do is in danger of being turned over because they happen to record it? Supreme Court gave that the back of the hand and said, oh no, we're taking jurisdiction, you have to turn it over. My own guess, it's no more than a guess, is because they already saw that Nixon was going down. And they didn't want to be on the wrong side of that page of history. But in any event, the most recent example was the Boumediene case, which is another Guantanamo-related case. This was about 2008. In Boumediene, the various prisoners in Guantanamo asserted their right to habeas corpus. And the government said, first of all, they're not citizens. Second, they're being held as prisoners of war, so this involves the war power exception. And thirdly, a little more humorously, Guantanamo is not a part of the United States, it's part of Cuba. Even though we had an umpteen-year lease over that and totally controlled what went on at Guantanamo. Supreme Court rejected all of those and held that habeas lies for the people in Guantanamo. And that, I think, was really a remarkable decision for a relatively conservative Supreme Court. The bad news is no one subsequent to that was able to get a successful habeas petition. Mostly this was handled by the DC Circuit, which at that time was a fairly conservative circuit. And they found other reasons to deny the habeas petitions that followed Boumediene. So it was, in that sense, a hollow victory. Nevertheless, it shows that the court, which made these exceptions, can unmake them in the right circumstances. Whether we will, in the near future, see any of those circumstances, I'm a little pessimistic, but we'll see what happens. In any event, all of this ultimately grows out of Federalist 78. So thank you very much. And I'd be happy to take any questions or comments.
You mentioned the fear that the executive would not enforce the judgment or decision. What if the president decided, or the executive branch decided under the president, to not enforce it, but the Congress passed a law saying you should?
So that was really what Marbury v. Madison was all about. And the court then ducked and said that's an unconstitutional delegation to the judiciary. Now, whether, there were unique circumstances there. Mandamus now is part of the weapons given to the federal judiciary by statute. So and those statutes, much subsequent, 100 years later, were not declared unconstitutional. So, there are a lot of reasons to believe that what was going on in Marshall's mind was a kind of, I want to have on paper that we have the right of judicial review, but I'm not going to fight the president over some justice of the peace. But nevertheless, the mere fact that Congress passed the law, as opposed to it being something that the executive did that was unconstitutional, would be a factor, but Marbury versus Madison shows it's not necessarily decisive, is my view. Yes?
So I'm trying to figure out.
By the way, I'm the deer in the headlight here, so I have a little trouble seeing. Go ahead.
Think about how you think about the Supreme Court's or federal court's relationship to state activity. So when we think about the three branches of government, we're talking federal government. Do you feel like the courts have been reticent with respect to state legislative activity different from state executive activity, or are states another animal, sort of, a legislative branch, an executive branch, and states?
Well, of course, there are always justices who are going to be more sensitive than others to federalism and federalism concerns. But I think the mere fact that it's a state decision, if it doesn't fall under one of the many other exceptions, would not necessarily be dispositive. I'll give you an example of a case I decided. So I was fortunate enough to be invited to sit on the Ninth Circuit Court of Appeals. My joke is, I already knew how to write reversible opinions as a district judge, but the Ninth Circuit is the home of learning how to write them as an appellate judge. So anyway, I was out there in the Ninth Circuit. This case was not reversed, by the way. In Tucson, Arizona, the school board had instituted a voluntary senior course in, this was not the exact title, but Mexican Pride would have been a fair statement of what the course was about. Many non-Mexican Arizonans felt this was very unfortunate. Ultimately, it became a statewide political issue, and they passed a law that on its face appeared to be neutral and required that every course have this, 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 and not have that. It was language about being balanced and so forth. It was only applied by the Attorney General and the State Superintendent of Schools to one course, and that was the course in Mexican Pride. So the case, the school teachers and the school children who were involved in that course sued in federal court. Case ultimately came before the Ninth Circuit. And I wrote the opinion for the Ninth Circuit, and what I said was that although it was a facially neutral statute, if you looked at all at the legislative history, if you looked at all at the executive enforcement history, you saw that it was motivated by and being applied in a invidious way against Mexican Americans. And so I threw out that law, and that was there was no cert granted by the Supreme Court, so that is the law. And the case then went to trial. I don't know the result. It went to trial about 6 months ago, but because they had also sued for damages. But that's the kind of thing a court could do in those situations. Not every court will do that. Other questions? Yes, sir.
Periodically, when Congress feels that the judiciary is likely to overturn a statute they're about to pass, they include a clause denying judicial review. Could you talk about that?
Yeah, I haven't had a case like that myself, so I only know very generally what you're talking about. But the jurisdiction of the federal courts within limits is determined by the Congress. So an everyday example is diversity jurisdiction. That has constitutional roots, but you could have a very different version of diversity. In fact, there's a statute called CAFA where if even a single member of a single one of the parties is of a different state, there's federal jurisdiction, whereas in everyday diversity cases, all the parties have to be from different states. So that's a good example of Congress exercising its authority over jurisdiction. But those statutes and those clauses are really not jurisdictional in nature, or at least that's the argument I think many people would buy into, that you can't carve out from the powers of the court a specific statute just by saying, and don't you dare review it. So that, I think, would be unconstitutional in many instances. Other questions? So, thank you so much.